Honorable Court is again in session.
Thank you. Thanks for your patience as we went a little long. We're here now on our third matter for this morning, State versus, and again, I'm going to make sure we say it right from the get-go. What is it?
Deprey.
Deprey, thank you. State versus Deprey, our case number 2020-0253, and we'll take appearances.
Natalie Scabine for Mr. Deprey.
Thank you, Ms. Scavine.
Good morning, Jeff Mann for the state.
Thank you, Mr. Mann. You both have done this. I don't think we need to say more other than confirm your, is it 3 minutes that you're
That's
reserving? Okay, then we'll go ahead and proceed.
May it please the court, Natalie Scabine for Mr. Deprey. We've raised several issues in this case, and I'm planning to start with the mistrial motion. In a case about self-defense, imperfect self-defense, and extreme emotional distress, all of which include a reasonableness component, the improper testimony at issue was an officer stating that Mr. Deprey was a felon and isn't allowed to carry a gun. Our best case on the issue of an officer volunteering testimony that was supposed to be excluded is Kraft. In that case, it was ineffective assistance of counsel not to make a mistrial motion where the issue was identity, and the officer testified briefly that the co-defendant said he was at the robbery when that was supposed to be excluded. So even if an officer makes a statement that the prosecutor did not intentionally elicit, and even if it's a brief reference, we look to the context of the case to decide if it is innocuous or if it is the kind of thing that requires a mistrial. And here, as defense counsel recognized, when making the mistrial motion, a mistrial was the only remedy that would avoid injustice in this case. So first, jurors are likely to be influenced by evidence about whether someone is a responsible gun owner, even in a case like this one where that is just inadmissible character evidence that is irrelevant to the question of whether the shooting was justified in the moment. And we know that this would have caught the jury's attention because the jury actually asked the very question the previous day of trial. The parties agreed that it couldn't be answered. The judge agrees that it couldn't be answered, but it was something they were interested in. And the possession by a restricted person charge had been bifurcated in this case for that reason as well. And then we have defense counsel's statement during the mistrial motion that the entire courtroom atmosphere changed right there and then at that testimony. And the court, when it ruled on the motion, said that the parties and the judge picked up on it, but that the court did not notice that the statement had any more impact on the jury than any other evidence that had been presented. But the state's whole case had been presented at this point.
So can you address the sort of deferential standard of review we apply in these cases, and explain as best you can why the choice the court made here, which was to strike the testimony and offer a curative instruction. I mean, it's not like the court didn't do anything here. Why that choice was an abuse of discretion?
Well, counsel was clear that a curative instruction wasn't good enough here, said that it would just draw attention to the issue. And in fact, counsel had said we would have cross-examined on the issue, except that would also draw more attention because what the officer said was not exactly what Mr. Deprey had said in that interview. So this was just the kind of evidence that was too prejudicial to be cured by an instruction, and the kind of thing that we knew the jury was interested in, and that when the question is reasonableness, and we have someone with a gun who shouldn't have had one, firing a shot that he believed was necessary at the time, but it may have been a mistaken belief. It's just too prejudicial for the jury to think that all of this would have been cured if you hadn't had the gun in the first place. And it's too distracting from the issue that they're actually supposed to decide, which is reasonableness in the moment.
What do we do with the notion that, and I understand that the defense is conceding that the jury would have heard that he was a felon and that he did have a gun. And so really the only fact is, and as a felon, he shouldn't have had a gun. That seems like a common sense enough notion that some jurors may know that already, and that the curative instruction could have actually helped so that jurors wouldn't be acting on an assumption.
So I don't think so. Some jurors may have known it. I don't think necessarily that jurors would know that. It wouldn't be on the front of their minds. And it wouldn't be something that they noticed the way that they would have in this case after it was a question that the parties had agreed couldn't be answered, that had to be excluded. And again, it was distracting from that important question of what's reasonable in the moment, and making them think about whether it was reasonable to be having the gun at all.
It wasn't dwelled on, I think, unless I'm confusing this with another case I heard recently. Judge Gibson seemed to think it was a comment in passing, it wasn't intentionally elicited. Nobody came back to it and made a big deal out of it. Consistent with the deferential standard that Judge Harris references, it seems appropriate for us to take those comments of the trial judge who was there into account. Those sort of carry a little weight with me, I have to tell you.
And it was, as defense counsel said, it wasn't the answer to the question that the prosecutor was trying to ask, and it was brief. But then we go back to Kraft and we say that when the case depends on this inquiry, when this is going to be a central and important component and the jury's going to notice it, there are just some errors that can't be cured, and sometimes a mistrial is necessary. And if there aren't any more questions on the mistrial issue, I'd like to move on to our preserved suppression issue, which was the discouragement from invoking the right to counsel. So the officer in this case told Mr. Deprey that he had the right to an attorney, but when he asked how long it would take to get one, the officer responded that he had no idea, and then proceeded both to offer legal advice and to discourage Mr. Deprey from seeking counsel. The officer told him a lawyer is going to tell us, the officers, to pound sand, but that if Mr. Deprey told the officers his side of the story, it would help the officers to be his advocate, to help him control the narrative. And the phrase that they kept repeating, or that he kept repeating, the officer kept repeating, was that it was going to make a big difference to the judge and jury if Mr. Deprey talked to the officer. And this went on to the point that at the end of this, Mr. Deprey believed that the next step would be sentencing, that he and the officer had reached some kind of plea or conviction, and they'd move on to sentencing next.
Yeah, the death penalty is somehow on the table already.
Yeah, and Mr. Deprey was concerned about the death penalty. And the question he was asking was trying to understand the right to counsel, and the response he got was discouraging and essentially trickery, saying like, an attorney's not going to let you tell your story. If you tell me your story, I'm going to become your advocate. And Miranda explained that evidence that the accused was threatened, tricked, or cajoled into a waiver will show that the defendant did not voluntarily waive his privilege. And then in Wood, in the portion as we argue in our briefs that has not been overruled, the court stated that a request for clarification may not be an attempt at persuasion to forego an attorney.
What do you make of the state's argument that because Mr. Deprey testified at trial, that his statements, whatever admissions he made to the officer during this interview, were going to come in one way or the other?
They would have come in as impeachment, and the trial would have looked different. So the way that it came in was at the last witness that the state put on was this officer to testify that he interviewed Mr. Deprey. Mr. Deprey started out by lying to them. He's confronted with the evidence. He starts crying. He wants to make this admission of guilt. The officer asks, did you see a gun or a knife? And he says, not to my knowledge. And then Mr. Deprey has to come in and tell his story with that being what the jury has just heard. But when Mr. Deprey tells his story, he explains, starting with the incident, that he was threatened, that he saw Mr. Hernandez reaching for something, that he believed his life was in danger. And then he moves on to talk about the statements that he made to the counselor and how he was trying to seem tougher than he was, which the counselor testified is something that he would do. And then he talks about his interview with the police and how, he was afraid of the death penalty. He just wanted it to be over. He said that he didn't see a gun because that was technically truthful, but it wasn't, the whole account of what had happened, because he did believe that there was a weapon, but he hadn't seen it yet. And so the impeachment that the state could have done with the interview would not have been much, because he could explain everything from his perspective, and he wouldn't have had to come right after the officer's testimony in the state's case in chief.
I'm curious on that point. I hadn't thought of it till just now, but is there any, I'm familiar with the idea of anchoring. We would talk about that in a personal injury context, that if whatever number the jury hears first, that anchors. Is there any research showing that that you can anchor a story as opposed to a number?
I'm not familiar with research on that, but I think it's pretty intuitive that when you hear the state's case in chief the way they did in this case, when you hear the officer talk about the interview the way that happened in this case, that you're doing, cleanup. You're trying to fix things, but you're not telling your story on a clean slate. And then I'd like to move on to the issue in the brief of the instruction on extreme emotional distress and go straight to prejudice here because that has been the state's argument. There was a reasonable probability in this case of a more favorable outcome on the murder conviction, absent the confusing instruction on the burden to prove extreme emotional distress. Essentially, if two burdens apply, one is heavier and one is smaller, the heavier burden just swallows the larger burden, right? If you have to win by two, of course you have to win by one. That part's not very important. So here, where there were some instructions that did correctly explain the burden, there was this instruction that explained that two burdens applied, and then there was the instruction on reasonable doubt that talked about criminal cases being applying this heavier burden in civil cases where it's only a preponderance of the evidence. So this would have been at best confusing to the jury, but we would argue more than that because again, two burdens apply. That's the same as just the heavier burden applying.
Okay.
You were first.
There should be a buzzer. Jeopardy.
You hit the buzzer first.
I understood the state's prejudice argument a little differently. I understood them to be saying that trial counsel didn't really argue extreme emotional distress at all. And instead, trial counsel argued self-defense, which is a defense that is somewhat incongruous with extreme emotional distress. I shot him on purpose because he was coming at me, not because I was under some extreme emotional distress. So, counsel gets to choose which defense they run. And so I guess the state's argument is, well, this error, if there was in this jury instruction about extreme emotional distress, didn't really matter because that wasn't really the defense. What do you say to that?
Well, counsel chose to run all of these defenses and is certainly within his rights to focus on the one that gets you a full acquittal instead of the one that gets you, 1 to 15 years in prison, but that doesn't mean that there wasn't strong evidence of extreme emotional distress. And we know that the jury really picked up on the extreme emotional distress aspect. They asked for additional guidance. The guidance they got referred them back to the instructions. The instructions were where the problem was. And there was strong evidence of both self-defense and extreme emotional distress. The one thing that was very consistent in Mr. Deprey's account of this was that Mr. Hernandez had done some terrible wrong to his friend, whether it was murdering him, whether it was robbing him, that this was someone who'd hurt someone close to him.
Well, and on that evidence, as I read it, it seems that before he ever showed up in the parking lot, Mr. Deprey had the idea that his friend may have been murdered. So that notion wasn't a new notion to him as he approached the car. Am I correct about that?
Right, but encountering the person who had done that, revived those feelings, and that kind of anger from something as serious as that would certainly not dissipate.
This wasn't the question I was going to ask when I was late on the buzzer. Judge Harris was apparently reading from my notes when he asked his question. I had the exact same question. This is a separate inquiry, and it seems that Mr. Deprey and his client spoke of anxiety and not extreme emotional distress. I mean, he was a little nervous. He said he had a lot of anxiety. As a matter of law, I'm not sure that equates to extreme emotional distress. It really wasn't developed because I think counsel primarily went with the self-defense angle too. But insofar as extreme emotional distress is lurking there, are references to experiencing anxiety enough to get us there anyway?
I think there are a lot of words we use to explain what is anger, what is distress, what is agitation. Anxiety, I think, is a good one. People use that word to describe a very serious state of distress. And it's also just what's reasonable under the circumstances where a reasonable person is going to be feeling that kind of anxiety, that kind of distress after seeing someone that they believe has murdered a friend. If there are no additional questions, I will reserve the rest of my time.
Thank you. Mr. Mann.
Good morning, may it please the court, Jeff Mann on behalf of the state. I'd like to begin with a brief global no prejudice argument before moving into the issues individually. This is a rare case where the evidence against the defendant included both a video recording of his crimes and multiple confessions. The security footage showed Deprey calmly walk up to a car in a parking lot, swing open the passenger door, immediately fire one shot, and then flee while discarding his coat and his hat. That video surveillance disproved Deprey's claim of self-defense, which was inconsistent with what the jury could see with their own eyes. Deprey also told his counselor that shooting was in retaliation to an alleged robbery, and explicitly denied that it was in self-defense. And then his changing story and ultimate confession to police would have been admissible at least for impeachment, even if it were excluded from the state's case in chief.
Well, in the forensic evidence that the victim was looking straight ahead, entry wound and exit wound, as I understand it, also somewhat inconsistent with self-defense.
Thank you, Judge Orm. Yes, there is also, that was inconsistent with self-defense. There was the DNA evidence on top of all of that. So looking at all of this totality of the evidence together, even if there were an error, there would be no prejudice to the defendant, and his conviction should therefore be affirmed. I welcome the court's questions. Otherwise, I'll begin discussing the two Miranda issues. First, the preserved issue is whether, after Deprey's ambiguous reference to an attorney, the detective had an obligation to ask clarifying questions or otherwise not allegedly discourage him from having an attorney.
Yeah, as I understand the defense argument, I don't think they're contesting the Davis case. I don't think they're saying that detective had to ask clarifying questions. I think the argument's a little more nuanced than that the things he did say were actively discouraging the invocation of or I guess the taking back of the waiver he'd already made.
Yeah,
I think that's the argument, isn't it?
If that's the only argument that they're making, then that's not preserved because it was not part of their argument below. The argument below was that there was some obligation on the detective to clarify what was going on, and the court's ruling was that unless and until he makes an unambiguous request, there's no requirement to do anything further. And that ruling is on page 356 through, I think, 358 of the record. So even if we go and talk about, discouragement, the trial court found that the court specifically said twice that it was his right? Once the defendant mentions an attorney, the defendant said, or the detective says that is a right of yours, and then later said you're more than welcome to get a lawyer. His discussion about, a lawyer's gonna tell us to pound sand was just the reality. If you do get an attorney, which is a right of yours, then we're not gonna be able to talk to you anymore.
The other statements that they're talking about aren't necessarily a reality, and in fact, maybe the opposite, that the judge is gonna look more favorably, the jury's gonna look more favorably if you'll talk to us, and we're gonna be helping you. And those kinds of statements do seem like cajoling. Is that?
I wouldn't say that that's cajoling. I think it's an encouragement to keep talking, which is permissible under Davis, for the reasons that detective wants to know what's going on, right? And there's a point also I think is important where defendants raise this, give me some piece of paper, I want to write it down. And detective says, no, we're just here to talk. You don't have to do all of that. And so it's showing his voluntariness, it's showing his understanding of what's going on. And then I'd also like to just add to the prejudice argument I made already, as Judge Harris pointed out, this is coming in on rebuttal as impeachment. It's not going to change the evidentiary picture to a significant enough degree that he's going to be acquitted based on self-defense.
Are there any admissions that the state thinks were material and made during this interview that couldn't have come in as impeachment?
No. And in fact, there are some statements that would have come in prior to any reference to an attorney. Regardless, they could have come in the state's case in chief. There's 4 in particular that I identified. On page 267 of the record, the first thing he says is that he wasn't at Czech City. He was nearby at a pawn shop. He heard a gunshot, and that's why he ran. So there's one lie the state could identify in his case in chief. The second, he lied about the path that he took. It's on record 276. Record 277, the detective says, hey, I know you were at Czech City. I know you were talking to some guy in a car out in front. And Deprey says, I didn't talk to nobody at Czech City. I didn't deal with any type of car. So there's a third lie. And then fourth, he lied about what he was wearing. He claimed he was only wearing khakis and a black shirt because he had gotten rid of his beanie and his coat and thrown that in a dumpster to try to, conceal his identity. So all of that's coming in regardless. You add that on top of the video evidence, on top of his confession to his counselor, which is probably, even without his confession, that's one of the most important pieces. The counselor says, did he come at you first with the gun? And he says, no, I shot him because he had robbed Homeboy or something like that. So you add all this together, there's just no reasonable likelihood that a jury seeing the video, hearing all this evidence, is going to think that that was in self-defense. The unpreserved Miranda warning question about whether the detective's statement, you don't have to talk to me today, is insufficient under Miranda. A competent attorney could reasonably omit a motion on that basis, based on a reasonable belief that it would fail. First, Miranda warnings do not have to be given verbatim. It just needs to generally convey the principles involved. And this court's case in State versus Warner had the detective saying, you don't have to talk to me if you don't want to, which is very close to what the detective said here. And so a competent attorney could review that, think that that argument was not very strong, and decide to put his resources in other areas.
Seems to me the strongest argument, I'm sorry.
No,
On-
you hit the buzzer first.
Going the other way is that Miranda itself says that the warning needs to be in clear and unequivocal terms. And putting that temporal limitation of today does seem to equivocate on the breadth of that right to remain silent. What would your comment be to that?
My comment would be that a reasonable attorney could not believe that to be the case. Just saying today, there's no addition to that saying, you don't have to talk to me today, but tomorrow you're going to have to talk to me. There would have to be something more there to make a reasonable attorney believe that a reasonable person, having heard that, would think that his rights are different from what this defendant has made clear. He understood his rights were, and he'd heard them before. There's no reason to believe that that would be significant enough for the defendant to believe that he actually didn't have the right.
Well, it's not part of your global no prejudice narrative, but when I read that, I thought, oh, that might be taken to mean you don't have to talk to me today, but you do have to talk to me in the very near future. I've come all the way to Oregon, for heaven's sakes. You're not going to avoid talking to me. It doesn't have to be today. But it strikes me that competent defense counsel might think, yeah, you pick that sentence apart, it could be read that way. I don't know that the court's going to buy that. I don't. It strikes me that at some level that's kind of a silly argument to make. It's close enough to the Miranda warnings. I'm going to choose not to burn any of my credibility making that argument. I mean, I see the grammatical point, or syntax, whatever, the temporal problem, but I guess it's not clear to me that all competent defense attorneys would seize upon that and premise their motion on that basis. Doesn't seem objectively deficient, even if it's something to pause and consider.
I would agree with you, Judge Orm. A competent attorney reviewing both Warner and the other cases cited in the state's brief at page 48, there's a lot of different ways you can convey this principle. They've done it here. We talk sometimes about how jurors do not parse jury instructions the way lawyers do. I'm sure criminal defendants don't either. He wouldn't have parsed that and said, oh, he said today, that's got to be significant, when obviously he's just commenting on today's the day that we're having a conversation right now. As far as prejudice go, I'd like to take just a moment to talk about State versus Beams and its discussion of the word meritorious. The Kimmelman case that Beams got that word from differentiated between preserved Fourth Amendment claims and unpreserved Fourth Amendment claims raised under ineffective assistance of counsel. And it used the word meritorious to say that when a defendant is brought a preserved Fourth Amendment claim, he has to show that his claim is meritorious, that, quote, prove only a search and seizure was illegal. In other words, he has to prove that there's a constitutional violation to get reversal. When the court then continued saying when the issue is unpreserved and it's ineffective assistance of counsel, that baseline remains that it's meritorious, that it would have succeeded, and you add on to that the layer of ineffective assistance of counsel, both deficient performance and prejudice. And if we were to change meritorious in Kimmelman to mean only a reasonable likelihood of success, that would mean that Kimmelman has said that you could prevail on a preserved Fourth Amendment claim by showing a likelihood that there was a constitutional violation. We know that that's not the case. You would never reverse a preserved claim saying that the court, we think the court might have erred, so we're going to send it back. This court's job is to determine if there was an error. And so that ineffective assistance adds to, does not take away from, what is required from a Fourth Amendment claim.
You never know if the district court's going to make the right ruling, though. Right? So when you're trying to decide if it absolutely certainly would have been granted, I mean, it's a little bit of a funhouse hall of mirrors, right?
But the question is not whether the court...
District judges aren't always perfect. They're not always going to make the right decision. So what we're trying to decide is, well, you know, would it probably have been granted, right? I mean, that's I think where ships are passing in the night on this whole Beams issue, if anyone cares what I think on this. But anyway, go ahead.
So I'd respond to that with, if all we're asking is whether it probably would have succeeded, then this court hasn't completed its job. Because if the case that the Beams opinion cited the dissent from, let's see, Lockhart v. Fretwell, the whole point of that case was that if the law had changed, the question is not what would have happened, but what should have happened. What did the law require? And so we don't ask the idiosyncrasies of a decision maker. We ask what is the law and was it actually violated? So asking whether it would have succeeded is not would the court have granted it, it's should the court have granted it because there was a constitutional violation.
And that would be the better way to phrase the rule, is
Yes.
the should language, not would.
I think that is the better way to frame it, that it should have been granted. If it had been raised, it would have, meaning it should have, because that's what the law required.
But we don't have any case yet saying that that is the standard.
Well,
Yeah,
I believe
and I'm
Kimmelman
not-
says
and
that.
I'm not sure that's inconsistent with Beams.
Yeah,
So,
depending on how you read it.
right,
There's not a lot of daylight in my mind, at least, between should have and would likely have.
right.
I think there's a lot of daylight there. I think saying, so what happened in Beams is you send it back, then they file the motion, and then we find out. The problem, part of the problem with Beams is that there were some facts that the court didn't realize, and it identified that in a footnote. Said we don't know for sure what other information would have come out, and that's why ineffective assistance of counsel claims require you to file a 23B, put all of that in the record so we know whether there was actually a constitutional violation. If we don't know, then we're not sending it back. If we took the same situation for a hearsay objection, for example.
So I guess I'm curious why you're spending 5 minutes of your precious 15 talking to us about Beams. You raised Beams in a footnote in your brief, but I didn't see an express Eldridge v. Jondro request for us to overrule it. So what are we doing here?
What we're doing is, I don't think we need a full Eldridge analysis when there's Supreme Court and Utah Court of Appeals precedent that says Beams was decided incorrectly, and so we're asking this court to fix that. And that Supreme Court case is State versus Martinez-Castellanos.
Yeah, that sounds like an Eldridge thing to me, but maybe I'm misunderstanding. You're asking us to go back and say Beams was wrong and fix it. That's an Eldridge scenario, isn't it? Tell me why it's not.
I think that Eldridge requires an analysis of whether something's been firmly established and all of these other factors, but when it's obvious that higher courts have already determined what the rule is, then this court should clarify that it had overstepped when it said what it said in Beams.
You're asking us to recognize an implicit overruling that's already happened rather than to make an overruling in the first instance. Is that the distinction you're trying to draw?
Whatever you want to refer.
Well, that
refer
can't
to
be
it
right,
as,
because
that's-
as I understand it, the cases you're citing to us from higher courts came before Beams. So it isn't that somebody came in later and said, oh, Beams was incorrect. What you're saying is, we in Beams, and two of us were you on Beams?
No.
Two of
I
us
wasn't
were on
on the
Beams.
court.
You're saying that we didn't digest the cases appropriately in Beams, and we need to fix it.
Correct.
That's Eldridge, right? There's no, you're just asking us to say we were wrong and to overrule our prior precedent and say something else. And I don't know that you do that in a footnote. I understand the state's all mad about Beams, but if you want us to take a look at that, you got to do it more than just a footnote and, appending it to your argument here in a case where this isn't really all that germane, right?
Okay. That's fine, thank you.
My 2 cents. I don't know what Judge Orm, the author of Beams, has to say
Well,
about
no,
that.
I mean, I think the court would be inclined to give that a serious look in a case where it mattered, where it affected the outcome. But if we buy your argument, there's nothing in Beams that stands in the way of you getting an affirmance. I mean, it seems like we typically will revisit our questionable precedents in a case where it's outcome determinative and not just sort of as a scholastic exercise, randomly overrule precedents in case where it really doesn't matter.
Well, the state's asked the court to reverse on no prejudice grounds. I've cited Kimmelman versus Morrison. I've talked about what meritorious means. I've cited State versus Martinez-Castellanos, and Beams is kind of out there as this contradictory authority.
So
I
it doesn't
believe-
seem to me that it needs to be overruled to get you where you want to go. It seems even applying Beams, you get there. I mean, assuming we buy your
Sure,
argument.
well, often the state makes multiple versions of an argument because we don't know which way the court's gonna go. I believe that it's important for the court to recognize what the higher courts have said, and so that's why I made the argument that I have. I appreciate your time considering that. I did want to make a couple points on the mistrial motion, if the court would like, has any questions about that or the other issues that have been presented.
I don't see any questions on that.
I thank the court for its time, and I ask the court to affirm Mr. Deprey's convictions.
Thank you, Mr. Miller.
Thank you.
Ms. Scabee.
Thank you. Again, Natalie Scabine for Mr. Deprey. So the specific issue that we preserved in Miranda was preserved below, or that we argued on appeal, as preserved was preserved below. It did evolve somewhat, but it was clearly preserved in the motion hearing at record 608 to 609, where counsel acknowledges Davis and then says, but what happened here was this discouragement from counsel. The court asked specific questions about it at that hearing, and then after that makes its ruling. And then the second point I want to make is that if the preserved Miranda issue was an error, then it becomes the state's burden to prove that that error was harmless beyond a reasonable doubt. So the prejudice, this global prejudice inquiry they're talking about, it will be their burden to prove that there is no prejudice beyond a reasonable doubt. And that brings me to a point that is kind of similar to the extreme emotional distress instruction, where once that burden applies, that beyond a reasonable doubt burden, it kind of swallows all the other burdens. So once once there is a constitutional error, the court can't say that the cumulative errors were harmless unless they were harmless beyond a reasonable doubt, because we do have that constitutional error in play. There was a question about the way that Mr. Hernandez was facing in the car, being straight ahead, not to the right. As counsel argued in closing, it's probably how someone's head would look if they were reaching for something, across their body while talking to someone at the window. I think those are the main points I wanted to make on rebuttal. If there are no further questions, we'd ask the court to reverse.
Thank you. Thank you both. We appreciate your arguments here and in the briefing. We'll take the matter under advisement and issue an opinion as soon as we're able. Thank you, and we'll now be in recess for the day.